A landmark judgment on colonial-era vagrancy laws has the potential to reshape criminal justice policy and practice in dozens of African countries. Now, the ruling was made yesterday at the African Court on Human and People's Rights. The vagrancy laws criminalize activities such as loitering, public indecency and begging. But for more on this story, I'm now joined via Zoom from Arusha in Tanzania by the CEO of the Pan-African Lawyers Union, Donald Deya. Mr. Deya, a very good evening to you. Thanks for joining us. Welcome to the Globe.
And thank you very much for having me on the Globe as well.
Let's talk about the landmark judgment that has been delivered by the African Court on People and Human Rights. What are the implications of this judgment?
This judgment is very good for us. Really, it's an advisory opinion in which the court has authoritatively determined that these offenses that we sometimes call petty offenses violate the African Charter on Human and People's Rights. They violate the African Charter on the Rights and Welfare of the Child. They violate the protocol to the African Charter on the Rights of Women in Africa, also called the Maputo Protocol. So the court has directed African states that they have an obligation, which in law we call a positive obligation, to repeal or to amend these laws or bylaws. That's what the court has done.
So when you say that the court wants all African states to abide by this particular judgment, does it mean that all African states in general, or those states that are signatory to the African Court on People and Human Rights Charter?
In the sense, first we have the African Charter on Human and People's Rights.
Yeah.
Then we have additional protocols to it, including the one setting up the court. As for the African Charter on Human and People's Rights, 54 of the 55 member states of the AU, that is everyone except Morocco, are parties to that charter. So to the extent that the court has interpreted that charter, it at least obligates these 54 to act. They've set up the state of the law for the continent. And of course, there's other work that we're also doing. We and our regional campaign team members are also doing around the African Commission on Human and People's Rights, which will help us as a platform to continue engaging the states to actually implement this judgment.
All right. Now, the Open Society Justice Initiative involvement argues that the vagrancy laws are sort of foundational to structural racism. How so? What is it that you've noted, rather from your perspective, what is it that you think the Open Society Justice Initiative has noted for it to come up with such an argument? And in terms of racism?
Let me just add that we work with the Open Society Justice Initiative, including on this one. We also work with the Human Rights Institute of the Open Society Foundations. They're among our campaign members. And they're very right. Over most of Africa, these laws were introduced in the colonial era. And they were determined, designed to just subjugate the native, to control how his movements, to force him or her to actually end up getting a job so that they could pay taxes to the colonial powers, and more or less to facilitate colonialism. That's what has happened in our context in Africa. But we do know that these laws also existed and still exist in other parts of the world. And literally what they're doing is criminalizing poverty, criminalizing otherness. So really, you go to, for instance, to the US, you can find that they're disproportionately applied against Black people and other minority people and so on. That's why we say that they've got their roots in structural racism and in our continent, in the design of colonialism.
So what is that rational and I would say, disproportionate connection between vagrancy laws and congestion in prisons?
Yeah, that is also an issue that we raised, because part of what we complain about is these laws, they are vague, they are overbroad. They are more or less designed in such a manner that the person that is accusing you ends up being judge, jury, and executioner all at once. He or she can interpret the law in any way to say that you've fallen afoul of it. As a consequence, we find that many of our prisons are full of people who have been charged with these offenses or been convicted of these offenses. Being a vagrant, being a rogue, being a vagabond, loitering, being without a fixed home, being without employment or means of subsistence, or sometimes even declare that a person cannot give a satisfactory account of himself or herself. So we don't need these people in prison. And that would really help. Removing these people from prison, cancelling this kind of laws would really help to decongest our prisons. And this is more so, for instance, at a time of COVID. you do not want people in congested places unless, it was absolutely unavoidable, and we think this is avoidable. So removing these offenses, or even going a first step and removing from prison people who are charged or convicted of these offenses, will significantly reduce our prison populations across the continent.
Mr. Deya, I would imagine an argument being raised by some African states, arguing that the application or the across-the-board application of this particular judgment is not fair, because in some states they don't normally arrest vagrants on the streets, but they only criminalize criminal activity. They only arrest those homeless people who are engaged in criminal activity. But then a link has been established in some instances between vagrancy and criminal activity, because when homeless people are poor and nothing to eat and nowhere to go, some of them often engage in criminal activity. That is when the law, or rather that is when the authorities pounce on them. So there's a bit of unfairness in that regard.
I wouldn't say so, and I'd be keen to see which study has established such a link, because I've not come across any. The studies we have done have shown that these laws are disproportionately deployed against poor people. If I was caught walking in the streets even at 1 a.m. with my good clothes and so on, police would not stop me, or they'd walk me home. But if a poor person was caught in the same circumstances, before he or she has done anything, they'll most probably harass him or her, arrest him, and throw them in. And as we're saying, if somebody has committed a particular offense, burglary, assault, battery, those are proper offenses that are known. We know what are the elements of that offense. But it is very hard to defend yourself against an offense like calling something that you cannot give a satisfactory account of yourself, because that's subjective. I'm the one that chooses. I think in all our societies, a certain percentage of people do commit crime, whether rich or poor, young or old, male or female. So let's focus on that rather than focusing on a class of people and collectively criminalizing them. After all, the biggest crimes in our countries are actually done by rich people. If you look at the corruption that has surrounded COVID-19 and the response to COVID-19 in most of our countries, that now is real crime that has led to the deaths of thousands of people who ought not to have died across the continent. So let's focus on that real crime and not on these crimes of status.
All right, Mr. Deya, great chatting to you. Thank you so much for your time.
And thank you too, and have a good evening.
You too, sir. That was the CEO of the Pan-African Lawyers Union, Donald Deya.